Morning. Good morning, everybody. This is Brad O'Dill. I'm the president of Reference Services. We've got a lot of information for you this morning about redacted information. Alicia, can you hear me okay? I just want to make sure.
Yes.
All right, great. So just part of our legal disclaimer, Stephanie, are you back with us?
I'm back. I apologize.
Okay.
My internet had a disruption.
All right, well, I'll let you take it from here.
Okay. So we're just going to start with our standard legal disclaimer. As a consumer reporting agency, we're here to provide educational information, not legal advice. So nothing shared in today's webinar should be interpreted as guidance from an attorney. And as you all know, I'm Stephanie, and I'm joined today by Brad, RSI's president and COO, and Alicia, our executive director of compliance and operations. And we also expect Heather to be joining us from our client relations team. Today, we are going to take a look at why redacting personally identifiable information matters and review the types of PII that are currently being removed from records. And we're going to take a look at some state examples to show how requirements differ and examine key compliance risks along with that, and also outline how RSI is adapting to those changes. We'll also cover what employers should be doing now and finish with a brief look at the future of PII redaction and compliance. And throughout the presentation, if you have any questions at all, please submit them in the Q&A chat and we will answer them as we go.
All right. Well, thank you, Stephanie, and thanks everybody for joining us today. This is a hot topic within our offices for sure. And as we do these quarterly compliance kind of calls, we like to bring awareness to our clients of issues that are certainly affecting the consumer reports that we publish and provide back to the client. And hopefully we can kind of peel the curtain back a little bit here and create a stronger work environment, because this is something that is ongoing. It's over the last 5 years has certainly increased a lot. So we'll try to talk a little bit more about what's going on with redacted information and why that is important to all of us involved in the process of putting out good consumer reports and hiring people effectively. But redacted personal information, and you'll hear us refer to PII, personally identifiable information a lot. These are driven by a lot of different changes, primarily trying to identify theft concerns, meaning everything is a public record. People can walk into courthouses, they can pull records, and they can see someone's address history. They can see, their date of birth. They can pull a lot of things that maybe you wouldn't want out in the public anymore. And so then you have state legislators and you have folks in various levels of government that are worried about privacy laws and how that affects information that maybe their cyber risk or data misuse issues that are out there. So a number of these things are kind of coming to bear about just protecting people's information as a foundation of it all. But we want to make something clear here. The results here is that background screening has fundamentally changed a lot in the last 3 to 4 years, especially in this space. And it's not always in ways that employers expect. One of the things that we want to just remind you of is the record still exists. The record is still public, but it's the identifiers that we rely on to match to those records are often gone or they're redacted. So we'll get into more about why that's important, but that's the fundamental about this discussion in general. So common redacted elements are full date of birth, and you'll see a lot of times we will see that often we'll only see the year. We won't see the month or the day. You'll see a full or a partial redaction of the Social Security number. Address history is one that is often removed completely. You'll see full legal names are often missing, or they'll miss pieces of the name, like maybe it's only the last name and middle initial, first name is gone. Driver's license numbers are often gone. Why is this a compliance issue? It's basically the Fair Credit Reporting Act, which governs what we both are responsible for, has a minimum requirement of 2 personal identifiers before we can put a record on a consumer report. Now, RSI's best practice is 3 identifiers, and that really comes to a lot of legal compliance and legal risk issues, and in the legal exposure that we as your consumer reporting agency are under, and then ultimately how that folds back to our clients. And so trying to find a full name and an address to match with a record, or a driver's license number, a social security number to match, is coming increasingly harder. And we're going to talk about the things that we're doing to help find more personal identifiers and work with our clients in that space. So I'm going to turn it over to Alicia. She's going to talk a little bit more in specific on what some of these states are doing, and then we'll circle back around.
Yes. So as you can see, there's a lot of states, and these are just a few examples of some of the states that have began the redaction. And there's many jurisdictions within the state that redact even more. So for like example, in Michigan, it says the date of birth is redacted. But many jurisdictions within that state also don't have addresses or driver's license or any type of social security number. So this means that the researchers need to work with the clerk to find additional identifiers for case records. So if counties are taking a little bit longer than expected, sometimes that's the reason. We or our researchers are trying to find additional information. The most recent challenging state has been South Carolina, where some of you might be aware, but we had no warning, but in January 1st, they began redacting everything except for name and year of birth. So the name is technically only one identifier, because in order for the date of birth to be used, it should be a full date of birth. So that's been really challenging. Most South Carolina counties are allowing clerk assistants to find additional identifiers. However, there are several counties and courts that will not work with researchers at all. So the workaround that we and most CRAs are using right now is the South Carolina SLED report, which is basically a statewide, but we're just using that to search for additional identifiers on cases that we've found, but we just don't have the identifiers to be able to report it. So we feel it's important to note that it's not just us, it's actually every CRA that's dealing with this right now. And I can tell you in the last 8 years since I've been here, it's just gotten increasingly difficult to report records. Quite a challenge. So this next slide just kind of focuses on the importance of us and our clients working together to ensure the accuracy of a report. The Fair Credit Reporting Act states that CRAs must have reasonable procedures to ensure maximum possible accuracy on our reports. It's important that the applicant information sent to us is accurate, because we're using that information as the basis for the report. Another way for us to work together is to let us know if the applicant self-discloses a criminal record, because we may actually have that record back, but we're searching for and struggling to find enough identifiers in order to be able to report it. We've also, another thing we've done is sent mugshots in the past to some clients to see if they recognize the person as their applicant. But the problem is that mugshots are not available very often at all. So when we get one of those, we're excited.
Yeah, Alicia, I think it's important to note, we actually, just to tell a quick story, I mean, we had a mugshot of an individual, or we thought we could get a hands on a mugshot of an individual in California. And then we were told by the California courts that it was against the law for California to share the mugshot. So even though we had something on this end, where the court wouldn't give it to us. And so we run into those kinds of things too. So it's almost like sometimes common sense is thrown out the window when it comes to some of these laws and rules that exist that the courts have to abide by in actually releasing information to us. And then you also run into the problem of just common names. I mean, you look at a James Smith, you know, how many of those might be across the country. So these are some of the things I want you to think about when you start thinking about just redacted information, and, you know, how we're trying to play a chess game of connecting the dots.
Right. Yeah. So we're all just trying to, even the courts included, are trying to make sure that they aren't sued. So everybody's very careful, but we feel like we're fighting the courts and the researchers sometimes. And then, like, the reason name only matching is such a high risk is for common names, especially for certain ethnic or cultural groups where census data shows less last name diversity. So because of this, common names require us to have 3 solid identifiers. And then, all of this is an issue, but solutions do exist. So some of the common strategies include kind of thinking out of the box. So the use of aliases and prior address. Just a note that it's good to encourage applicants to list any prior names that they may have had. Our social security trace does include prior aliases, and that actually helps us to locate some cases that might not have been, in the report name. But once we've found the case, we have to find additional identifiers for it. So we can't use an alias that was derived from address history or from the social security trace. We have to find additional identifiers. Some jurisdictions will work with researchers to supply additional identifiers, some will not. We may be able to find additional identifiers by ordering a statewide search. And then most CRAs, including us, have begun offering biometric identification tools where an applicant is required to take a picture of their driver's license and themselves. This verifies that the person submitting the report is the correct person, while also verifying that the date of birth and social security number are accurate. This also helps us on the back end by providing a photo and driver's license number for some of those records that do include that information.
Alicia, I might mention, we may reach out if we don't have biometrics set up on your specific account. If we ran into a dispute issue or where we're trying to connect the dots on identifiers, we may call you and ask you if we can send a biometric request to your applicant because we need to confirm an identity in some way. So these, we've done that too outside of the original request for background screening information. And then I would also note that our platform doesn't require a middle initial because not everyone has a middle name. However, it's in all of our best interests if you would talk to your applicant and say, hey, it's asking for a middle initial, make sure you put that in there, because that's always a really helpful piece of the puzzle if we can get that on the initial applicant information that they put in, or you may put it on their part.
Yeah, that is important, especially for common names. So yeah, good thought. So yeah, the focus kind of in our industry has changed a little bit to processing controls for the accuracy of the report. And I just wanted to kind of note one additional thing is the Professional Background Screeners Association, which we're accredited through, is actively fighting to, against the redaction. They're trying to work with lawmakers. They're trying to convince them to at least give our industry special access to some additional identifiers. So we're hopeful that one day we'll have a better solution for all of this, but right now it's just a struggle. So I'll go ahead and turn it over to Stephanie.
Thank you. So we're going to look at some compliance risks for employers. So even though public records may now contain redacted or missing information, the employer obligations remain exactly the same. HR teams are still responsible for making fair, accurate, and compliant hiring decisions, and redactions don't lessen your risk. They just change how that risk needs to be managed. Under the Fair Credit Reporting Act, we must use reasonable procedures to ensure maximum possible accuracy. When information is incomplete, the chance of a record being incorrectly matched to a candidate naturally increases, which makes accuracy even more critical. If a mismatch occurs, it can lead to candidate disputes, delays in hiring, and even issues in the adverse action process, which may carry legal exposure. So that's why clear documentation and careful record matching and consistent adverse action procedures are so important. So what should employers be doing right now? First, anytime a candidate discloses a record to you, please loop us in. As we mentioned before, it is considered an additional identifier if the applicant self-discloses that information. So that could be the difference between us being able to report things or not. It's also a great moment to revisit adverse action workflows. So with more redacted data out there, it's even more important that your process is consistent, your notices are going out correctly, and your timing follows the FCRA. Another big one is to listen for disputes. If a candidate pushes back on something in their report or says something doesn't look right, just send them our way, and we will handle the dispute and reinvestigation process from there, so you don't need to manage that. On the HR side, some quick training topics can go a long way. So please help your teams be prepared for occasional delays and the possibility of inconclusive results, and to know exactly when something should be escalated to compliance or to RSI for clarification. This is also a good time to take a fresh look at your background check policies. Make sure they reflect the reality that data limitations exist now, and avoid assuming that a clean report automatically means this person has no history. Sometimes that information simply isn't available. And finally, just be ready for more gray area scenarios. With more redactions, you may see more potential match or inconclusive results. So naturally, that means more candidate questions, a few more disputes, and sometimes longer timelines. So setting expectations with your hiring teams ahead of time really helps smooth things out. So overall, stay connected with us as your partner, update your processes where needed, and prepare your teams for the new landscape, because we're here to help you get through it.
And thanks, Steph. I might add too, with regard to disputes, it's important that everybody realizes that an applicant does not have to use the term dispute in their conversation to kind of set off that red flag. If at any moment they challenge the report and say, that's not mine, or I don't agree with that, I mean, that technically starts a dispute. And we, as your CRA, have a very rigid process of handling disputes to make sure that we're protecting the applicant and giving them an opportunity to give us information to change that report. So again, we handle that on your behalf. Just make sure that if you have a conversation that your candidate has raised any red flags at all, you make sure you contact us and then ask them to call us as well, and we'll handle that dispute process. And then lastly, I'm just going to cover what we think is kind of the future outlook of, where are we going with public records? And we can confidently tell you that more states are adopting this redaction first policy. You just have a lot of people in the process at the court levels and at the legislature level that are their first thought is to protect the candidate information and data security. So you're going to find that more states, and we showed you that list earlier, but more and more states and even local jurisdictions are going to be redacting information. And so this is an evolving landscape for sure. It's all based on increased privacy legislation. We're going to have reduced reliance on public records for sure. And then there's going to be just more scrutiny over the decision-making process for hiring at a greater level. And then another topic, kind of a sidebar topic, but one we wanted to put out there, is this ban the box issue. And I think, Stephanie, we were going to put a link in the chat. Yes, Stephanie just did that. There's a website called findlaw.com that's done a really nice job of showing the ban the box issues by state. And if you're not aware of that, ban the box basically is you cannot have a box on your application that asks the applicant about their criminal history on the initial job application. Check your state, make sure you understand the law, but I can tell you this whole ban the box thing is floating across the country as well. So it's making all of our jobs a little bit harder when it comes to uncovering what's happened with records in the past. But the records still exist. I want to remind you the records still exist. We just have to be better at working together to kind of protect or kind of connect the dots, if you will. It's not a perfect data anymore, but we do have of ways to handle this imperfect data responsibly, and that's the key as well. So would like to kind of turn it back over to Stephanie with just takeaways, and then please throw any questions at us that you might have.
Yeah, I don't think I see any questions. Heather, have you seen any questions coming in?
The only question I've had so far is if we're going to be sharing the slides, and I told her that we would be sharing the recording with all attendees.
Perfect. All right. So we will jump in with the key takeaways. So first, the compliance is really about the process, not having perfect data, like Brad said. With so many redactions happening, the goal isn't flawless records. It's making responsible, well-documented decisions and partnering with a compliance screening partner like RSI to help you navigate the gray areas. We're also seeing more and more states expand public record redactions, which means access to key identifiers used in background screening is becoming more limited. Even with these changes, your compliance responsibilities as an employer haven't changed. You still have to follow the same rules, even if the information you're working with is less complete. Because fewer identifiers are available, matching risk naturally goes up. That can lead to errors, delays, or more candidate disputes, so it's important to be prepared. Another important point, screening results are starting to vary by jurisdiction, which means the old one-size-fits-all background check process doesn't work as reliably as it used to. And finally, it's a great time to proactively revisit your internal policies. Make sure they reflect today's realities and demonstrate that you're taking reasonable steps to stay compliant in a changing landscape. Those are the key things to keep in mind moving forward. A few reminders before we wrap up. Please check the RSI news and announcements on the client portal often for important updates, including upcoming webinars, county delays, and compliance news. And also, as always, you can contact compliance@referenceservices.com with any questions that may follow this presentation.
I do have a question.
Okay.
Sorry to interrupt. Got a question from Jean. Can you review the possible outcomes from your research that would be reported to a client? For example, if you see a record but cannot confirm an appropriate amount of identifiers, is the client notified by a potential match finding? What other outcomes might a client receive? So I believe, so if we cannot report the record, and Alicia, correct me if I'm wrong, if we do not have enough identifiers, you would just receive no records. Is that correct, Alicia?
Yes, that's correct. Because if we notify you of a possible record, that is basically reporting the record. And that's what we can't do with not enough identifiers. So unfortunately,
But
we wouldn't.
I would add to that, Gene, in answering your question, we are going to be forced in some ways to communicate with you more often as we're trying to look for identifiers. So in some cases, you kind of have to kind of read between the lines, because if we're asking you for more information, you can assume we're probably looking at something. And I tell people all the time too, a clear report is going to come back in the standard day or two. And if you haven't gotten something in a day or two, we're probably doing some homework on a report as well. As Alicia said, it's a high risk for us to tell you about a potential record and give you any more detail. But there are some assumptions that you can go under, that maybe you could ask for a candidate story. That's something that we're looking into too, some technology to where maybe you think there's more there, and you can inquire with the candidate to try to get the candidate to reveal some things to you. And if that happens, see, that may be another identifier that we can use to actually put it on a consumer report. But at the end of the day, what we put on that consumer report is what we're, can legally be challenged with. And that's what we have to be mindful of. And so you asked the question of a potential match. A potential match might be, we have a record that sits in the same jurisdiction where they've lived, but what we don't know is if we've got the right person, because we don't have a name match, or we don't have an address match, or we don't have a social security match. So the potential just exists because maybe it's name only match, and we just don't have enough identifiers to report it. So again, we're not saying that's your person. We're just saying, hey, the potential exists that this could be, and we're searching to see if we can connect the dots.
All right. I don't think I see any other questions coming in.
No, I
Um,
do not either.
Okay, so like I said, if there are any follow-up questions, please feel free to email us at compliance@referenceservices.com. And just as another reminder, a copy of the slides and recording will be emailed to anyone who registered for the webinar. And we would like to thank you all for attending today. We really appreciate it.